Yeah, may I proceed, sir?
Yes.
Hope I am audible, sir.
Yes.
So, sir, continuing with my yesterday's submission, sir, I was on the point of lack of territorial jurisdiction raised by the appellant, original different number one, for the purpose of assailing the judgment and order passed by the trial court below Exhibit 5. So just to recapitulate, to maintain continuity, so it is the contention of the appellant, original different number one, that the commercial court at Vapi is not having a territorial jurisdiction, and hence the impugned judgment and order would qualify as one without jurisdiction. Sir, yesterday I pointed out that on this very issue, they moved an application under Order 7, Rule 11 for the purpose of rejection of the plaint. I invited the attention of the Honorable Court to page 595, which is their application under Order 7, Rule 11, and I drew the attention of the Honorable Court to relevant page 600, wherein they have raised this plea of jurisdiction having been conferred upon the courts in Germany, and therefore plaint is required to be rejected. I also invited your Honor's attention to the order passed by the trial court in respect of their application under Order 7, Rule 11 at Exhibit, it was at Exhibit 27, and the order passed by the trial court is at page 608. And I pointed out that this order has attained finality because this order has not been challenged so far by the appellant different number one. And based on that, now I'm continuing further. Based on that, my submission, when I concluded my submission yesterday, was that once a court of a competent jurisdiction has decided a particular issue or a particular point, then it is no longer open for any party to the civil suit to re-agitate that point in the civil suit or in any proceedings arising out of the civil suit. That order is binding and holds the field. If they are permitted to raise the contention of territorial jurisdiction in present appeal from order, sir, it would have the virtual effect of requesting your honor to sit in appeal over that order in respect of Order 7, Rule 11 application, for which the appeal would not lie before your honor. There is no appeal provided in Civil Procedure Code against an order passed under Order 7, Rule 11. The remedy lies if revision is maintainable, subject to the provisions of the commercial code. But be that as it may, today that order is not a subject matter of challenge in the present appeal. So they are precluded, estopped, precluded by way of principle of estoppel and res judicata. And I said that I will be now citing judgments on that. But sir, before I cite judgments on this proposition, so there is an interesting point which I must point out. Sir, when they filed the reply, when different number one, the present appellant, filed its reply to the injunction application before the commercial court, our application at Exhibit 5 to be, they filed the reply at Exhibit 9, page 500 of the paper, 580 of the paper. Page 580 of the paper is the reply of original different number 1, the appellant before your honor, to our application, to their application rather. I'm sorry, to our application. I'm sorry, to our application under Order 39, Rule 1 and 2, to our injunction application. Now, sir, the relevant part, which is worth noting for the purpose of present point, is on page 588. Page 588. While replying to our injunction application on merits, at page 588, Vide paragraph 10, there is also a contention of lack of territorial jurisdiction. And it is worth noting how they have raised. The plaintiff has conveniently suppressed the fact that it has agreed to submit to the exclusive jurisdiction of Frankfurt courts only, to the exclusion of all other court jurisdiction, for the purpose of determining the disputes, rights, and liability arising from transaction process. The defendant number 1 refers to and relies on its separate application under Order 7 Rule 11 of CPC in this regard. So there also, for the purpose of raising a plea of lack of jurisdiction, they relied upon their application under 7 Rule 11. Therefore, even on this count also, when their application under Order 7 Rule 11 is rejected, and their reply to our interim injunction application was referring to that application only, unless and until that order is interfered with by a court of competent jurisdiction, they cannot raise this point again and again. Sir, since we are on page 588, I may also invite the attention of the Honorable Court to paragraph 11, which is relevant for my other point. Additionally, the plaintiff has filed interim application and accompanying plaint before this Honorable Court on the basis defendant number 2's registered office is the jurisdiction of court. However, all communication related to transactions, including process note 1, plaintiff's inclusive offer, process note 2, and plaintiff's first and second offer, where exchange between the plaintiff and PwC acting on behalf of defendant number 1 shareholders. Defendant number 2 was not involved in these exchanges. Therefore, it is clear that defendant number 2 has been added as a party to the suit, and this interim application to manufacture jurisdiction where none exists. Therefore, plaintiff's interim application is without jurisdiction. So, for the purpose of raising a plea of jurisdiction, their submission was twofold. 1, exclusive jurisdiction conferred upon, agreed to be conferred upon courts at Germany. And second, defendant number 2 has been wrongly joined just to create, and if I have to use their language, to manufacture a jurisdiction. So I don't know how jurisdiction can be manufactured, it can be created. Anyhow, they have chosen to use that expression. But sir, this contention also would no longer be available to them, because defendant number 2 also moved an application under Order 1 Rule 10, contending that they are wrongly joined as a party to the suit. They have nothing to do with the suit. Therefore, they may be deleted as defendant number 2. So, a prayer for deletion under Order 1 Rule 10 was sought by defendant number 2 also. And that application is not on the record, but I am making a statement at bar that that application was also, that application is there. That application is also there. Page 633. Page 633 is an application moved by defendant number 2. Order
1 Rule 10(2).
633.
Yes.
Paper move. Application filed by defendant number 2 under Order 1 Rule 210. So they also filed an application on this very ground that they are not concerned with the transaction and there may be deleted. That application was also rejected by the trial, by the commercial. Therefore, both the contentions raised, rather twofold submission made by the defendant number 1, present appellant, for the purpose of disputing the territorial jurisdiction of the commercial court at Vapi, were independently dealt with by the commercial court at Vapi in respect of its order, create two separate applications, one under Order 7 Rule 11 filed by different number 1, other under Order 1 Rule 10 filed by different number 2. Both the orders have attained finality. Therefore, even on this count also, different number 1 present appellant is stopped from raising any contention with regard to the territorial jurisdiction of the commercial court at Vapi. Now, once I say that they are stopped by a principle of issue estoppel and res judicata, I must make good my submission by referring to the case law on the subject. My submission is that what I have submitted is duly supported by the judgments of the Honorable Supreme Court. Sir, first judgment on which I would like to place reliance is the judgment in the matter of Hope Plantations Limited versus Taluk Land Board, reported in 1999, 5 SCC, page 590.
590.
Page 590. Is it there physically? Physically is available. Then we can, if it is not there, sir, we can. This, we have made an error. I am citing the.
Yes, it is there.
Hope Plantation, 1999. Now your honor may turn to paragraph 26 of this judgment, where ratio has been laid down.
It is settled law that the principles of.
Yes, it is settled law that principles of estoppel and res judicata are based on public policy and justice. Doctrine of res judicata is often treated as a branch of law of estoppel, though these two doctrines differ in some essential particulars. Rule of res judicata prevents the parties to a judicial determination from litigating the same question over and again, even though determination may even be demonstrably wrong. When the proceedings have attained finality, parties are bound by the judgment and are stopped from questioning it. They cannot litigate again on the same cause of action, nor can they litigate any issue which was necessary for decision in the earlier litigation. These two aspects are cause of action estoppel and issue estoppel. These two terms are of common law origin. Again, once an issue has been finally determined, now this is the line on which I would like to put emphasis. Again, once an issue has been finally determined, parties cannot subsequently in the same suit advance arguments or adduce further evidence directed to showing that the issue was wrongly determined. Their only remedy is to approach the higher forum is available. The determination of the issue between the parties gives rise to, as noted above, an issue estoppel, and it operates in subsequent proceedings. This is very material. It operates in subsequent proceedings in the same suit in which the issue has been determined. Posing for a moment here, sir, before I read further. The Honorable Supreme Court says, once a point is decided in a suit, you cannot raise that point in the suit again. Appeal is a continuous proceeding of the suit. Nonetheless, it is clarified that even in a subsequent proceedings arising out of the suit. So this would qualify as both continuation of the suit as also a subsequent proceeding arising out of a suit. The Honorable Supreme Court says you cannot raise that point unless that point is dealt with by a higher forum appropriately. It also operates in subsequent suit between the same parties in which the same arises. Section 11 of the Code of Civil Procedure contains a provision of res judicata, but these are non-exhaustive of the general doctrine of res judicata. Legal principles of estoppel res judicata are equally applicable in proceeding before administrative authorities as they are based on public policy and justice. Because the Section 11, as your Honor is well aware, would come into play if a subsequent suit is filed. And therefore, in this matter, why the Honorable Supreme Court clarified that Section 11 is not an exhaustive provision. It may be referring to a suit, but we read the concept of res judicata, principle of res judicata, in a manner where it would subserve its object, meaning by which it may be the same suit, may not be a subsequent suit, or a proceedings arising out of the same suit. That point cannot be re-agitated on a principle of issue estoppel and res judicata. So, second judgment on this point is in the matter of Murti Devi by Honorable Allahabad High Court. Murti Devi, it is 2009 SCC Online, Allahabad 124. So, paragraph number 15 may be seen.
15.
15, paragraph 15.
Yes.
It starts with the, after leaving some line, the principle of res judicata.
Yes.
After leaving some line,
Yes. Yes.
the principle of res judicata not only apply to separate proceedings. Am I with your Honor?
Yes. Yes.
The principles of res judicata not only apply to the separate proceedings, but also in subsequent stage in the same proceedings. The same court, namely the executing court, could not have again considered the question of right of ownership, which was decided by it in the trial of the suit. The principle of res judicata also applies as issue estoppel in the stages in the same proceedings. So there's a trial court took one view. When it came execution, it tried to take a different view. The Honorable Allahabad High Court says it's a continuous proceeding. So I would like to say that appeal from order being either a continuous proceeding or subsequent proceedings in the suit as observed by the Honorable Supreme Court, the principle would be equally applicable of res judicata and they are estoppel. So last judgment on this point, which is very comparatively recent and very elaborately dealt with by the Honorable Supreme Court in the matter of S. Ramachandra Rao.
Yes.
2022 SCC Online 1460. Sir, here the facts I'll just briefly narrate so that principle can be well appreciated. Sir, in a suit, the plaintiff was represented by his wife, who was also an advocate and also holding a journal power of attorney of the plaintiff. And the issue arose, can she represent her husband as a party in person on the basis of the general power of attorney issued in the favor? So the trial court took one view and said that yes, she could represent. And that order was confirmed. So later on, in a subsequent proceedings arising from the same suit, when matter went before the High Court, the High Court said that yes, the earlier view which we had taken appears to be not correct and we would like to correct and now say that she can not appear on the basis of a general power of attorney. So in that context, the Honorable Supreme Court addressed the issue. This was the paragraph number 18.
Yes.
Having regard to the background aspects and the rival contention, we may first of all take up issue of res judicata before moving to any other issue raised in these appeals. Learned counsel for the appellant has contended with reference to various decisions, including that in the case of YB Patil versus YL Patil, 1976, 4 SCC 66, that doctrine of res judicata is attracted only in a separate subsequent proceedings, but also at a subsequent stage of the same proceedings, and hence the concluded orders passed earlier in these proceedings are binding on the parties. The learned counsel has argued that the issue as regard to the conduct of the case by the wife of the appellant on his behalf and in her capacity as general power of attorney holder has attained finality in these proceedings with the concluded order dated 20th April 19 and 14th December 2018 as passed by the High Court, and as such an issue cannot be reopened at the subsequent stage of these very proceedings. It has been contended with reference to several decisions, including that in the case of so-and-so versus so-and-so, that even an erroneous decision, if rendered between the same parties, binds them if the same had not been decided by a court of competent jurisdiction. The learned counsel also referred decision of so and so as regard distinction between a precedent and the operation of a doctrine of res judicata and to a decision in so and so versus so and so cannot be ignored even on the principle of per incurrem, because those principles have relevance to the doctrine of precedence but have no application to the doctrine of res judicata. Sir, posing for a moment here, with your Honor's permission, the Honorable Supreme Court, while reiterating the principle that once a point has been decided in a suit, it cannot be re-agitated either in the suit at any stage or any subsequent proceedings. The
So you
Supreme
would
Court has
convey that it is appellant cannot raise the issue of
yes.
his,
Yeah,
jurisdiction
but
and
one
all.
more aspect, one more aspect important. Honorable Supreme Court says even if that order is erroneous,
Yes.
it is to be corrected by the appropriate court having jurisdiction to sit in appeal. So today my learned friend, of course, he has not argued, but he cannot even argue that that point has been decided against me wrongly. And this very judgment, sir, thereafter, the other paragraphs, I'll just point out, paragraph 24, because another issue was raised, that res judicata section 11 is referable to second suit. There also it has been negated by the Honorable Supreme Court, para 24.
Para 24.
24. It is equally relevant. 24.
Yes.
It is equally relevant to reiterate that section 11 CPC is not the foundation of the doctrine of res judicata, but merely a statutory recognition thereof, and hence is not considered exhaustive of the general principle of law. The doctrine it is recognized is conceived in larger public interest and is founded on equity, justice, and good conscience. These aspects were tersely put by the court in the case of so-and-so versus so-and-so. The fact that a section 11 of the Code of Civil Procedure cannot apply on its terms, the earlier proceeding before the competent authority not being a suit, is no answer to the extension of principle underlying that section to the instant case. Section 11, it is long since stated, is not exhaustive, and the principle which motivates the section can be extended to cases which do not fall strictly within the letter of law. Because section 11 is honor is available, is applicable to second suit. The Honorable Supreme Court said, no, we would not like to go by the restricted meaning. Section 11 is a statutory recognition of principle of res judicata. Otherwise, principle of res judicata is wide enough, and we would apply the same in the same suit and same proceedings, subsequent proceedings arising out of the same suit also. And then, sir, relevant paragraph is paragraph 25. It hardly needs any overemphasis that but for this doctrine of res judicata, the rights of the person would remain entangled in endless confusion, and the very foundation of maintaining rule of law would be jeopardy. Even if this doctrine carries some technical aspect, as explained by the court in thereof, it is in the interest of public at large, and a finality should be attached to the binding decisions of the courts of competent jurisdiction, and it is also in public interest that individuals should not be vexed twice. Then, sir, paragraph 27, the conclusion is very important. The principle that doctrine of res judicata is attracted not only in separate subsequent proceedings, but also at a subsequent stage of the same proceedings is hardly of any doubt or dispute. A three-judge bench of this court, in case of Y.B. Patil, has tersely underscored the principle of law in the following terms. It is well settled that the principle of res judicata can be invoked not only in the separate subsequent proceedings, they also get attracted in a subsequent stage of the same proceedings. Once an order made in the course of proceedings becomes final, it will be binding at the subsequent stage of that proceedings. Now, sir, you may consider appeal as a continuation of the suit. That also applies. If you consider subsequent proceedings at a later stage arising of the suit, then also this principle applies to Honorable Supreme Court. So, viewed from any angle, they are stopped from raising this. Yes. Now, sir, I turn to my next submission. Hope I am clear with the Honorable Court so far as this aspect is concerned.
Yes, yes.
Now, sir, therefore, on this principle, the issue of territorial jurisdiction raised by them on both counts, because, sir, other count is the different number 2 has been wrongly joined. That also would not be available to them because separate application moved by different number 2 is also rejected by the trial.
Yes.
Now, sir, despite this, let us examine, without prejudice in my submission, that this, despite the judgment of the Honorable Supreme Court, stopping them from raising this point. Sir, even on merits also, even if this Honorable Court is having a jurisdiction to look into that issue, ignoring those orders passed by the commercial court, which have attained finality. So then also, the submission of defendant number 1, appellant, that jurisdiction is restricted to the courts at Germany, is wholly devoid of substance. And I'll make good that. Sir, if we look at their contention, so their contention in Order 7 Rule 11 application is that later inviting us to submit our indicative offer, which was called later for phase 1, process 1, contained a clause restricting the jurisdiction to the courts at Germany. Now, sir, Your Honor may just have a look at that later clause. Your Honor would find that clause on page first original third. I just say. I'll give the page number. Original third 3rd June 2020. Later, indicative offer. So I'll just give the page number. Clause
Page number 45 છે.
45 આવશે.
Project process later. Project
That this later shall be clause number. This later original 7 છે. Just a moment, sir. I'll confirm the page. Because મારું પેજિનેશન પેલી ઓરિજિનલ પેપર બુક નું છે અને આ લોકોએ નવી પેપર બુક આપી છે મારી મિસ્ટેક. This
Third
later.
letter છે ને ધોલભાઈ?
First indicative offer first. offer in
That is 3rd June. Private and confidential, it was written on.
બસ સર એમાં પ્રોજેક્ટ
Yes.
એમાં સાહેબ ઇન્ટરનલ પેજ 7 ઇન્ટરનલ પેજ 7 સાહેબ પેજીસ ઉપર હશે
Right.
પેજ નંબર 50 સર લાસ્ટ લાઈન જે જ્યુરિસ્ડિક્શન ક્લોઝ એમાં આવે છે This letter shall be governed. Am I with your order?
Gone by and construed in accordance with German law.
Yes, these letters shall be governed and construed in accordance with the German law, excluding its conflicts of law. And you hereby irrevocably submit to the exclusive jurisdiction of the courts of Frankfurt, Germany.
Right.
So they are emphasizing on this communication, this letter. So this says this letter, meaning by which, so long as this letter holds the field, આ લેટર જ્યાં સુધી સાહેબ અસ્તિત્વમાં હશે ત્યાં સુધી એક્સક્લુઝિવ જ્યુરિસ્ડિક્શન જર્મની કોર્ટ ને એવું થયું સાહેબનો મતલબ. Now this letter is only for the purpose of inviting us to give our indicative offer. That is available from the very first paragraph of this letter. Very first page of the letter, 3rd paragraph. We are pleased to invite you to participate in phase 1 project. Am I with your order?
Yes.
So this letter is only for the purpose of inviting us. Then we were called upon to submit our offer. And then your honor may turn to clause 2 on page number clause 2, next steps. A number of parties who have submitted indicative offer may then be invited to participate in phase 2 of the process which involves. So this letter clearly says this is phase 1. It is mentioned at the top also phase 1. In phase 2, if we are selected, we will be invited. So this letter contains a clause restricting jurisdiction of the Germany court with express qualification. These letters shall be governed by. Meaning by which, if any dispute takes place in respect of this letter, which was only for the purpose of inviting us to give our indicative offer, the court at Germany would have a jurisdiction. આ કાગળનો કોઈ પણ ડિસ્પ્યુટ થાય. હવે સર આ કાગળનું મહત્વ માત્ર ઇન્ડિકેટિવ ઓફર સબમિટ કરીએ ત્યાં સુધી. એકવાર ઇન્ડિકેટિવ ઓફર સબમિટ કરીએ એટલે આ કાગળનું અસ્તિત્વ પતી ગયું. પછી જો અમને ફેઝ 2 માં બોલાવવાના હોય તો એના માટે નવો લેટર ઇશ્યુ કરવાનો અને એ લોકોએ કર્યો. હવે યાર ઓનર મે ટર્ન ટુ phase 2 letter, where your honor will not find this clause at all. Sir, phase 2 letter is on page. I'll just put it. But then I can make a statement without troubling your honor. In phase 2 letter, this clause is not there. And to me, just to complete the phase 2 letter, I just
Phase 2 proceedings.
phase 2 sir.
Page 182 પર છે.
1A.
Process letter 2, project road runner.
Yes, right, sir. Absolutely right. Now, sir, આ કાગળની અંદર પેલા કાગળનું સાહેબ પતી ગયો, નવો આવ્યો. In this letter, there is no provision for this clause. એમાં સાહેબ ચોખ્ખું લખ્યું કાગળની અંદર કે thus thank you for your continued interest in project runner. Then we are pleased to inform you that Jinda so and so the plaintiff has been selected to participate in phase 2 project. Now sir, phase 2 project માં જેનાથી આ લેટર આવ્યો પેલો phase 1. આ phase 2 લેટર ની અંદર કોઈ પણ જગ્યાએ એવું કોઈ જ ક્લોઝ નથી કે જેનાથી એક્સક્લુઝિવ જ્યુરિસ્ડિક્શન જર્મન કોર્ટને જાય સાહેબ. એબ્સોલ્યુટ એક સાહેબ આખો જે ક્લોઝ છે એ એમાં નીકળી ગયો. Therefore, the clause on which they are putting emphasis is in respect of phase 1 later. Phase 1 later had a limited life. That life came to an end moment we were issued phase 2 later. Therefore, their contention, assuming your honor can examine it without prejudice, my first submission that it is barred by principle of res judicata and issue estoppel. Even if it is to be examined, there is nothing in phase 2 pursuant to which the contract came to be concluded. Sir, in my respectful submission, the contract came to be concluded in response to our offer, which was in furtherance of this phase 2 loiter. And એમાં કોઈ જગ્યાએ સાહેબ આ ક્લોઝ નથી. Therefore, sir, in my respectful submission, assuming without admitting and without prejudice to my contention that the issue of territorial jurisdiction, they have no right to raise, they are estopped by principle of res judicata and issue estoppel as laid by the Honorable Supreme Court. Even on merits also, this contention is wholly devoid of substance. Now, sir, during the course of the argument, as it appears, I would say, realizing that it is difficult to bank upon that clause conferring or restricting jurisdiction upon courts at Germany, which was in respect of phase 1 later. So, realizing that difficulty as it appears, during the course of the hearing, reliance was placed on a provision made in share purchase agreement and it was contended that even a share purchase agreement is having a clause restricting the jurisdiction to the courts at Germany. Now, sir, my share purchase agreement, your honor would find on page original 273. It's part of, I'll just give the pin number. 20th September. No, email share mash. Page number, original 273. Sir, in a moment, sir, we are signing them. Three 360, sir. Huh?
3-6.
316. 316. So this is, if your honor turn to a page before that, 360, there is an email. 20th September. Yeah, 31. Email क्या है? So 314 may be see. 314 first. Whereby they annexed 314 is emailed by from their side to the plaintiff. Dear Sudhir, many thanks so and so. As an immediate next step, many thanks for your SPA share purchase agreement markup on project. Please find attached our counter markup prepared by so and so team. So any have annexed to share purchase agreement. Jennifer, they are putting lands now, which is on the page 314. That share purchase agreement. And a share purchase agreement, they are relying on clause 22 at page. Clause 22 at page Governing arbit law. Governing law.
354.
I'm obliged, sir. 354. Now, sir, during the course of the hearing.
Governing law arbitration.
Yes, sir. Now, sir, point to be noted is, so far as the reply to our injunction application, as also their application under Order 7 Rule 11 is concerned, they are banking on process letter 1 for phase 1 for contending that jurisdiction is restricted to the courts at Germany. During the course of the hearing, they tried to place reliance on this clause in share purchase agreement, saying that even in share purchase agreement, this clause is there. Now, sir, my submission is twofold. Number one, sir, share purchase agreement, on one hand, they say it is not a concluded contract. I say that share purchase agreement terms were agreed, only formality of signing was left out. Now, when they bank upon this clause, sir, obviously they are admitting that share purchase agreement was concluded between the parties. So they cannot run on two horses. They cannot blow hot and cold together. It's not permissible for them to approbate and reprobate. So on one hand, they say that share purchase agreement is yet to be arrived at, and therefore there is no concluded contract. My contention is that contract was concluded. Share purchase agreement was a formality to be carried out as a consequence of a concluded contract. Now, when they bank upon this clause in the share purchase agreement for the purpose of raising the point of territorial jurisdiction, sir, in my respectful submission, they are virtually admitting that this was concluded and mere formality of signature was left out. Be that as it may, sir. This clause also is not supporting the case of appellant FR number 1, that jurisdiction was restricted to the courts at Germany. The reason is, sir, if your honor takes the trouble of comparing this clause with the clause which was there in the process letter 1. Sir, in the clause at process letter 1, if we go back again to that clause, so the expression used was submit to the exclusive jurisdiction of the courts at Frankfurt, Germany. Sir, clause which was there in process letter 1, 3rd June, categorically mentioned submit to the exclusive jurisdiction of the courts at Germany. Whereas this share purchase agreement, upon which now they are trying to place reliance, though according to them it is not a concluded contract, does not contain that particular expression that we have decided to submit to the exclusive jurisdiction of the court at Germany. Therefore, let us read that clause at serial number 22. Page number 314. No? 314. The first, 22.1. These agreement and any non-contractual obligation arising out of or in connection with it shall be governed by and construed in accordance with the laws of Germany, without regard to the principle of conflicts of laws and excluding the United Nations Convention on contracts for the international sale of goods. So we do not find anything in this clause which is there to restrict the jurisdiction to the courts at Germany. There is no reference of courts at Germany. It simply says, when it comes to interpreting this clause, this share purchase agreement, recourse will be made to the laws of Germany. Only for the purpose of interpretation of this. It never says the courts at Germany would have the exclusive jurisdiction. That provision was there in phase letter 1, process letter 1, 3rd June 2024. This provision is not there. Clause 22.2. All disputes arising in accordance with these agreements or its validity shall be finally settled in accordance with the arbitration rules of the German Institution of Arbitration without recourse to the ordinary courts of law. The place of arbitration is Munich, Germany. The number of arbitrators is 3. The language of arbitral proceeding English, provided the evidence may also be submitted in Germany language, so and so. The applicable substantive law is in German laws. Now, sir, in my respectful submission, this clause speaks about arbitration. Sir, if there is a provision for arbitration, and according to them, on account of that, it is not their case that because of the arbitration clause, the suit is not maintainable. Because if that is so, they have to move an application under Section 8 of the Arbitration and Conciliation Act seeking stay of the order, which they have not done. Sir, provision of an arbitration, as your Honor is well aware, would not debar the suit. Though there is an arbitration provision, suit can always be filed. It is open for the defendant to object to such a suit by giving an application under Section 8 of the Arbitration and Conciliation Act 1996, which they have not done. Therefore, in my respectful submission, even if your Honor is to examine on merits their contention on the issue of lack of territorial jurisdiction on the part of the commercial court at Vapi, then also it is not possible to afford the contention of the appellant different number 1, because there is nothing even in this share purchase agreement restricting the jurisdiction to the courts at Germany as sought to be contended. So that provision was there only in process letter part 1, which was valid till process letter part 2 was issued. Therefore, on merits also, there was no case. Now, sir, there is another aspect of a territorial jurisdiction. Sir, if we look at the provisions of Code of Civil Procedure, sir, Section 16, which is very relevant, Section 16, which is in respect of suits to be instituted where subject matter is situated.
Subject to the pecuniary or other
Up to the pecuniary resolution, this law, so for recovery of immovable property, for partition of immovable property, for foreclosure, determination of any right. Now, this is very much clause D. For determination of any other right to or interest in immovable property, for compensation for wrong to immovable property, for recovery of movable, actually, that I am concerned with clause D. So, any suit concerning any interest in an immovable property or any suit claiming any right in respect of an immovable property or any interest in immovable property is required to be instituted in a court where the immovable property or other in a court within the territorial jurisdiction of which the immovable property is located. So suit is to be instituted in a court within the territorial limits of which the concerned immovable property is situated. Now, sir, it is our specific case that if this transaction was to go through as per concluded contract, then defendant number one, which is a wholly owned subsidiary of defendant number one, and that defendant number two, which is having its registered office, its plant, everything at Vapi, would come to us. Because when we acquire 100% shareholding of defendant number one, defendant number two being the wholly owned subsidiary of defendant number one, even defendant number two with all its assets would come to us, and its assets are located within the territorial limits of the territorial jurisdiction of the commercial court at Vapi. Further, sir, we have also pointed out in paragraph 27 of our plate then how the transaction was to go through. Transaction was to go through, that we have explained that an Indian entity was to be created which was to take over so far as different number two was concerned. Sir, paragraph 27 of my plate, if your honor turns to paragraph 27 of the plate, I think plate that paper book page
767.
the paper book mark plate mark
Seven?
mark paint paper book
767.
760.
767.
767.
plain amended paper.
767. Yes. Pertinently in the month of September and October
Yeah,
2000.
pertinently in the month of September and October 2024, the plaintiff and defendants conducted various meetings, including the management meetings, principal meetings, meetings regarding SPA, transaction timing, and other commercial matters, including the proposed transaction security structures. Details of the proposed transaction structures and fund flows were also discussed via emails and provided in the preliminary draft on the confirmation of sufficient financing for Uber Group and its individual entities as part of the acquisition by RBC Jindal Group prepared by FTI so and so as part of the corporate restructuring. This is very material. The Uber Group was proposed to be split up. In the first step, European purchaser B would acquire all shares of MHM, that is plaintiff. Consequently, acquiring MHM, following that, MHM would sell Uber Group India to India purchaser A. Further site visit to Poland, Frankfurt and Munich were also being proposed between the parties on October 14 in order to close the pending points. The plaintiff as well as advisors wrote emails to the defendants referring to that discussion and requesting for expert session while sharing a list of critical queries, copy of all these things. So, sir, in my respectful submission, this is how the transaction was to move further. So, in that scenario, in my respectful submission, this on the commercial court at Vapi was otherwise having a jurisdiction. It's not that defendant number one has been roped into the controversy simply for the purpose of creating a jurisdiction as sought to be contended by them. So this is another aspect to show that their contention on territorial jurisdiction is wholly devoid of substance. Now, sir, with this, I turn to other contentions raised. Because, sir, there are major contentions. Because now, if I now turn to other contentions, which are minor in nature. So, their major contentions were twofold. That there is no concluded contract, which I dealt with yesterday. Then, second contention, the court is taking territorial jurisdiction. It was on 2 counts. One, clause in the contract conferring a restricting a jurisdiction to the courts at Germany. And secondly, different number 2 has been implemented just to create a jurisdiction. Both I have dealt with. First of all, they are stopped from raising that point. And secondly, when otherwise also on marriage, they have no case. Now I turn to some other contentions which they have raised. Sir, one of the contentions was to the effect that though the transaction was between the shareholders of different number 1 and the plaintiff, and on account of the same, though other defendants were nowhere involved in the transaction, were nowhere privy to the transaction, not only they have been implicated in the suit, but the trial commercial court at Vapi has granted an injunction against all defendants. So, in substance, the relief which at the most could have been granted against the shareholders of different number 1 has been granted against all defendants who are not the shareholders of different number 1. Sir, I will deal with this contention. Sir, first of all, in our plaint, we have categorically stated that defendant numbers 3 and 4 are the persons representing defendant number 1 as shareholders of defendant number 1. Now, sir, if defendant number 1 is of the view that defendant number 1 is least concerned, is not at all concerned with the present transaction, and therefore order of injunction should not have been passed against defendant number 1. So also if defendant number 2, 3 and 4 are also having the same impression, then in that case, in respectful submission, there is no need for them to challenge the order. If they are not concerned, say for example, sir, if I am not to demolish a particular structure, a suit is filed, seeking that it is apprehended that the defendant is going to demolish my construction for which he has no right. Restrain the defendant from demolishing the construction. Despite contention of the defendant that I am not going to demolish the construction, the apprehension is wrong. Despite that, the court feels that no, a case has been made out and the apprehension is well founded, and I would like to injunct defendant from demolishing the construction by way of a temporary injunction. So in that scenario, if defendant is not to demolish the construction, he cannot be said to be aggrieved by the order of the trial court. There is no need for him to challenge. If he challenges, that means that what he is trying to contend before the court that he is not going to demolish is falsified. So same analogy is applicable here. On one hand, the different number one says that yes, my shareholding can be disposed of. My equity can be disposed of by my shareholders. I am not concerned. If that is so, what is the need for different number one appellant to prefer this appeal? What is the need for different number two to support the appellant in the present appeal? Now, sir, look at their further conduct. They are not disclosed. Now, sir, before I go to their conduct, different number 3 and 4 appear before the commercial court at Vapi. Moved an application and order 1 rule 10 containing that we are not the shareholders and we may be deleted as defendants number 3 and 4 under order 1 rule 10. We have been wrongly impleaded. That application is also rejected by the trial court and it holds the field. Therefore, even on the same analogy of issue estoppel and res judicata, they cannot say that defendant number 3 and 4 are no longer concerned with the dispute even though they have been injuncted. Sir, in my respectful submission, it is not at all open for defendant number 1 appellant as also for the rest of the defendants to raise any grievance on the ground that though they are not concerned with the dispute transaction, they have been injuncted, injunction has been wrongly granted against them. Sir, on the contrary, in my respectful submission, defendant number 1 is also equally concerned with the concluded contract. So also defendant number 2 and defendant number 3 and 4. Now, sir, look at their conduct when they are raising that contention that defendant number 3 and 4 are not the shareholders. Look at their conduct. Sir, they are not disclosing in their reply, rather they means defendant number 1, appellant, is not disclosing in his reply to the injunction application as to who are the shareholders of defendant number 1 if defendant number 3 and 4 are not the shareholders. Sir, when I moved an application, when the plaintiff moved an application for amendment of the plea, for the purpose of impleading defendant number 3 and 4 in their correct name as shareholders of defendant number 1. So initially, if I have to just give the factual background to your honor, so initially defendant number 3 and 4 were not impleaded in their correct name as shareholders of defendant number 1. They were described little differently, though their names were there, but they were described little differently. Having realized that mistake, plaintiff moved an application for amendment of the plea. And that was for the purpose of correcting the cause title and showing difference number 3 and 4 as shareholders of different number 1. Sir, that application was opposed, but it was never pointed out in that application, reply to that application, that different number 3 and 4 are not the shareholders, but some other persons are the shareholders. That application came to be allowed. Resulted in different number 3 and 4 came to be impleaded. Having it impleaded, different number 3 and 4 are moving an application under order 1 rule 10, saying that we have been wrongly joined, we are not the shareholders. There also they are not disclosing anything. Before your honor, a chart was submitted. If your honor, so during the course of the hearing, a chart of how the shareholding pattern different number 1 was submitted.
Yes.
If your honor have a look at that chart, and this would go to indicate their conduct. Sir, when they say, because chart was submitted to show that shareholders of different number 1 are concerned. So in the chart, they said that first shareholders of MHA Group holding GmbH, and they appointed Price PwC as their agent, and then say hold shares of different number 1. Then they say these two are holding the shares of whole shares of different number 2 and other subsidiaries. So different number 1 holds the shares of different number 2 and other subsidiaries. But they are anything they are not disclosing this. Then if not different number 3 and 4, who are the shareholders of different number 1? So when they thought it fit to contain that different number 3 and 4 are not the shareholders, despite the application of different number 3 and 4 on this count having been rejected under order 1 rule 10, they are not pointing out to the honorable court that if not different number 3 and 4, who are the shareholders? Therefore, sir, even on this count also, their contention deserves to be rejected. Next, the next contention is, now sir, one more aspect on this. Now sir, one more aspect. Sir, all emails, I can give you, sir, page numbers of all major emails, which I would call correspondence between the parties. Sir, page 401, 403, 407, 408, 409, 411, 412, 413, 414, 415, 416, 417, 418, 423, 424, 425, and 426. All these correspondences, sir, which are major one, were marked to difference number 3 and 4. Their email IDs are there. Sir, if difference number 3 and 4 not at all concerned, and if they were not representing difference number 1, what was the need to mark all emails to them? Not only that, in their press release on page 429, 421. Sir, if you refer to their press release, when they committed a breach, sir, they had a press release.
Consortium of Mavco Investments and Avenue Capital.
Yes, sir. Yes. That press release, sir. Just a moment. I'll find out. There, the name is there.
Press release is
Yes. That page.
Singapore.
Yes. Press release. And there, yesterday also I pointed out, since we were on this document, that there is a name of different number 3 as a shareholder of different number 1. I'll read that line. Huber Group, a global leader in specialty chemicals and print solutions, is pleased to announce the signing of a sale and purchase agreement with a consortium between Mavco Investments, a private investment vehicle belonging to select members of the Muruguppa family. Yes, Muruguppa family. Yes, sir. I spelled pronounced differently. Funds managed by Avenue Group so and so, the consortium will acquire, now this line is very material, the consortium will acquire all the shares in the company from the current owner, considers so and so holding, that is different number 3. The completion of this transaction is subject to the required regulatory approvals. So different number 3's name is figuring in their press release as a shareholder of different number 1. Their own document.
Yes.
Therefore, sir, in my respectful submission, it is no longer open for them to contend that though different number 3 and 4 has also different number 1 and 2 are no way concerned with this transaction, they have been injuncted. And as I been mentioning, sir, right from the beginning, if they are wrongly injuncted, they should not bother. If they are not going to execute the transaction with another party, if they are not involved, because injunction says here you are restrained from proceeding further and maintain a status quo. If they were not to move further, if they were not to engage themselves with any kind of relationship with this group, which I pronounced wrongly, so if that group, the third party, then in that scenario, they should not be bothered. The simple analogy which I gave, that if I am not going to demolish the construction, and if I am injuncted, why should I bother? If I challenge that order, that means that I have an intention to demolish, and I am pretending wrongly that I am not going to demolish. Therefore, sir, in my respectful submission, this argument of theirs, that injunction has been granted to a person or to a party who is no way concerned, is wholly devoid of substance. So the next contention which they raised was that there is the present suit, it was sought to be suggested or contended, that present suit is essentially a suit for a money claim and not a suit for specific performance of a contract. Sir, in my respectful submission, this contention deserves to be discarded at the threshold for the simple reason that my very first prayer in the suit is for specific performance of the concluded contract. And my specifically, if your honor takes the trouble of turning to the plaint once again, sir, my prayer in the plaint my prayer is on paragraph number 27. Paragraph says 70. 70.
Page 785.
Yes. First prayer, an order for specific performance. The suit itself is for specific performance. Merely because I, in the alternative, prayed for damages, which is my right. Sir, any suit for specific performance, it is always the right of the plaintiff to pray for damages in alternative. So my prayer is, see that you act as per the concluded contract. And alternative prayer is, pay me breakup fee of 9 million euro, which you would agree. That is my alternative prayer B, D, in the alternative. So to say that my suit is not for specific performance, but essentially for a money claim, is, in my respectful submission, wholly misconceived submission. Then there was another contention raised that we have not made any investment for this concluded contract, and without parting with anything, I am seeking specific performance. Sir, my submission is the question of making payment would arise as per the terms of the concluded contract. And as per the same, upon signing of share purchase agreement, which in my respectful submission a mere formality, we were made to make the payment. We have never said that we would not like to make payment. Sir, yesterday when I was taking your honor to the correspondence, I pointed out that at one point of time we also showed to them our financial strength. And today also I am instructed to make a statement that if they are ready, willing and prepared to abide by their word and go ahead and go further on the basis of the contract which according to the plaintiff is already concluded, sir, we are ready, willing and prepared to make the entire payment as agreed. We are not going to back out of that. Sir, I can be faulted, sir, in a suit for specific performance. An objection can be raised with regard to not having been parted with any consideration, provided terms of the contract cast an obligation upon the plaintiff to make some payment and which he has not made. Suppose for agreement for sale, a provision is there that you have to make the payment of 50% by this particular date of the consideration. And if I have not made that payment, and if I go for specific performance, it can be questioned that without parting with any money, any part of the consideration, I am insisting for specific performance. And so far as, sir, our expenses are concerned, it is ever in the play that before this contract was concluded, sir, we made frequent visits to Germany. We had a due diligence. We visited their plant, inspected their plant at Germany. In India also at Vapi, we had frequent visits. Sir, we had multiple negotiations. We also engaged agencies in Germany to move further with this project. So it's not that we have not incurred any expenses. We have incurred around 40 crores. So it's not that, sir, we have not incurred any expenses and we are just simply trying to, as they call it, arm twisting tactics or a blackmailing tactics. No, we are not here. We are genuinely here for our right. Now, sir, another contention was raised by respondent by different number one, present appellant, by referring to impugned judgment and order, that there are certain anomalies, there are certain contradictions in the impugned judgment and order. Sir, before I deal with this, I would like to reiterate my first submission that this is not a regular appeal. And we are at the stage of hearing of a stay application. In a regular appeal also, it is permissible to have an appreciation of evidence. But in an appeal from order, even if appeal from order is to be taken up for hearing, reappreciation of the evidence is not possible. If that is so, much less at the stage of the hearing of the stay application. But regardless of that, I will demonstrate that not a single contention raised by them finding fault with the impugned judgment and order is sustainable. The reason is this. So their first objection was that the trial court, rather commercial court, took a different view in the impugned judgment and order on the issue of concluded contract in juxtaposition to the view taken by it when it passed an order under section 12A of the Commercial Courts Act. So what happened, as your honor is well aware, when we file a suit as a commercial suit, there is a requirement of mediation. Without exhausting mediation, we cannot straightway file a commercial suit. And if there is an element of urgency, one has to move an application under section 12A of the Act, Commercial Courts Act, seeking exemption from pre-mediation as a prerequisite for filing a suit. So we moved an application, the present plaintiff moved an application under section 12A of the Act, Commercial Courts Act. In respect of that application, the Commercial Courts Act passed an order saying that I do not find any need to exempt you from pre-mediation before entertaining your suit. While passing that order, the commercial court made a tentative observation that I am unable to find a concluded contract. So I concede to a fact that when that order was passed by the trial court, by the commercial court, a tentative observation was made that I do not find a concluded contract. But that order is my respectful submission when challenged before the division bench of the Honorable High Court by the plaintiff. Sir, it was quashed. And suit was directed to be entertained by the commercial court without relegating the plaintiff to mediation. So when that order is quashed by the Honorable High Court, and while quashing that order, nothing was saved in respect of that order. Sir, can it be said that commercial court is bound by its tentative observation in respect of its order under section 12A of the Act? Sir, answer is obviously no. Something which is observed in an order which is caused by the High Court would never bind the commercial or for that matter any court. Therefore, in my respectful submission, the conclusion reached by the commercial court on the aspect of concluded contract can never be questioned by referring to the order passed by the commercial court in respect of the application of the plaintiff under section 12A of the Commercial Courts Act. Then, sir, another contention was raised that in para 1 of the impugned judgment and order, the commercial court has mentioned that defendant number 1 intended to dispose of 100% shares of defendant number 1, which is wrong. Shareholders of defendant number 1 intend to dispose of and not defendant number 1. Sir, in my respectful submission, what is meant by the commercial court in the impugned judgment in paragraph 1 of the plaint is shareholders of different number 1 intend to divest. So merely because reference is made of different number 1, so you cannot mechanically construe to say that the commercial court has committed a grave error of construing the facts wrongly. Sir, otherwise also, defendant number 1 being a company can never sell its shareholding. So its shareholding can be disposed of only by the person holding the same, that is the shareholders. So sir, a slip of pen, I would say it's a slip of pen. A slip of pen in one line of the order would not render the entire order as bad. You have to read at the order as a whole. And if the order is read, impugned order is read as a whole, it clearly conveys that what was sought to be disposed of was the shareholding of different number 1 by the shareholders of different number. So therefore, sir, this is too hyper technical to say by picking up one line that there is an error apparent in the impugned judgment and order. Then, sir, such other minor things were also contended that in para 9 of the impugned judgment, it is stated that it is not disputed that a suit property is in Vapi. Because there is an observation in para 9 of the impugned judgment that suit property is located at Vapi. They say there is no suit property located at Vapi. Now, sir, again, one line is sought to be picked up from the impugned judgment out of context. What the learned judge intended to convey was that assets of response number 2, different number 2, are within the territorial jurisdiction of the commercial court and Vapi. Sir, when they say that, because, sir, it is our case that as per the concluded contract, assets of response number 2 were also to come to us. So in that context, this observation has been made in paragraph 9. Sir, you can't just pick up one sentence out of context. A mere slip of pen is highlighted to say that trial court has not properly construed the facts. Then, sir, it was contended that in paragraph 11 of the impugned judgment, it was wrongly concluded by the commercial court, that was their contention, that correspondence reveals that indicative offer and final offer were accepted by the defendants. Sir, in my respectful submission, yesterday I took your honor to entire correspondence to point out that not only our indicative offer was accepted, because our indicative offer was accepted, therefore we were on to enter phase 2. Once we enter phase 2, our first final offer, then revised offer, and that went on. And that's an conclusion the trial court has reached on the basis of appreciation of correspondence on the record as the evidence on the record. Therefore, sir, in my respectful submission, this contention is also wholly devoid of substance. Then, sir, it was contended that in paragraph 20 of the impugned judgment,
Paragraph
20,
yeah.
the order passed by the Honorable High Court has been wrongly quoted. Now let us read paragraph. They emphasize on the word, this court impliedly believes. Am I with your honor? In paragraph 20, there is a sentence. This court impliedly believes that High Court also satisfied that this suit is of interim urgent nature. That observation is there. Am I with your honor?
Yes, yes, yes.
Now they say that this is not the order of the Honorable High Court. In my respectful submission, if you look at the order of the High Court has in fact observed that this is a suit wherein there is an element of urgency, and therefore it is required to be heard without relegating the plaintiff to the requirement of premediation. So in my respectful submission, there is nothing wrong on the part of the commercial court in quoting the order of the High Court in this manner. Sir, if the commercial court has not said that merely because High Court has said there is an element of urgency, I am straightway granting an order of injunction. The commercial court says, as per the order of the High Court, this matter is required to be heard urgently. And in fact, that was the order of the Honorable High Court. And thereafter, the commercial court examines the matter on merits and comes to a conclusion that this is a fit case to grant a prohibitory order of injunction. Then, sir, several other paragraphs, I will not invest time of the Honorable Court, several other paragraphs were pointed out. So, in my respectful submission, all findings of the trial court are based on appreciation of evidence on record in the form of the correspondence, which can never be objected to or a question in an appeal from order under 43, considering the narrow compass from appeal from order, much less at the stage when your honor is considering application for stay moved in appeal from order. So now, sir, with this, I turn to my next submission. Because I have assured the Honorable Court that I have to finish today, so I'll be finishing it. So I am just moving a little fast. Sir, this is a suit for specific performance. Now, sir, after the amendment of Specific Relief Act in the year 2018, there is a sea change in the concept of right of the party to seek specific performance of an agreement. Sir, prior to the amendment in the year 2018, specific relief, specific performance of a contract was construed as a discretionary relief, meaning by which the plaintiff cannot claim specific performance as a matter of right, even if the contract was established. It was open for the concerned court in its discretion to refuse specific performance. So that was the concept. Now in 2018, the amendment was introduced in Specific Relief Act. And as per that amendment, Section 10 of the Specific Relief Act in its amended version would read like this: the specific performance of a contract shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, section 14 and section 16. For the first time, by way of an amendment, shall word came to be used. In respect of specific performance of a contract when it is prayed for. This section 10, upon its amendment, came to be interpreted by the Honorable Supreme Court in a case reported in 2023, 1 SCC. So before that, I'll take one more case. So came to be came to be interpreted first in C. Haridasan, yes. Case reported in 2023, SCC Online
Yes.
Supreme Court, page 36.
Hmm. एक मिनट हाँ, only 5 minutes.
हाँ। Sure. Yes, sir.
हाँ दोल में Asi
हाँ।
Haridas versus
Haridasan. Paragraph number 63. Paragraph number 63.
By
By
way
way
of Civic Relief Amendment Act.
by way of Specific Relief Amendment Act,
Hmm.
Section 20 of the Act has been substituted, thereby rendering the relief for specific purpose to be statutory remedy instead of a discretionary remedy. Previously, the unamended provision granted the courts the discretion to deny the relief of specific performance on the basis of judicially developed exception, even where it would otherwise be lawful to direct specific performance. Now, such statutory created exception have been excluded. The Amendment Act has eliminated the discretion of the courts in cases involving specific performance of a contract and grants of right to an aggrieved party to such specific performance of a contract in certain cases, subject to the provisions contained in Section 11 to 14 and 16 of the Act. The section deals with the cases in which specific contracts connected with the trust being enforceable, contracts of which cannot be specifically enforced, and personal bar relief, respectively. So, unless and until the case falls under section 11 subsection 2, section 14 and section 16. So these are the sections. 11.2 will refer to the trust. 14 will refer to the contracts which cannot be statistically enforced. And 16 will refer to the personal bar. Our case does not fall in any of these sections. The Honorable Supreme Court says with the amendment of Specific Relief Act, the relief is now no longer discretionary. It is statutory as a matter of right. So meaning by which, if I prove the concluded contract, which I have prima facie, then specific relief or specific performance is as a matter of course. No discretion is left with the court. Considering this in my respectful submission, the injunction, temporary injunction as prayed for, has to follow when I am in a position to establish a strong prima facie case as held by the commercial court and party about the concluded contract. Sir, initially, pre-amendment in a suit for specific performance, since the relief was a discretionary relief, it was open for the court to consider whether to grant temporary injunction or not, even if the contract was established. But here, once the contract is established, it is no longer open for the court to deny specific performance, and therefore, when a prima facie the contract is believed by the trial court at an interim stage of the matter, the injunction has to follow. So the same view came to be taken by the Honorable Allahabad High Court in 2019 SEC Online Allahabad 5523 Mukesh Singh case. Mukesh Singh. Mukesh. Sir, paragraph 29. Specific Relief Act 1963 was extensively amended by the Specific Relief Amendment Act 2018. The paragraph 29.
Yes.
Specific Relief Act 1963 was extensively amended by the Specific Relief Amendment Act 2018. By the aforesaid amendment section 6, 10, 11, 14, 15, 16, 19, 21, 25 and 41 were amended. Existing section 14 was substituted by new section 14, 14A, and the existing section 20 was substituted by the new section 20, 28, 20B, 20C. The discretionary jurisdiction of the courts to decrease specific performance was done away by newly substituted section 20 by the Act of 1820. The newly substituted section 20 makes specific performance of a contract a general rule, then exception subject to certain limited grounds. The newly substituted section provides for substituted performance of a contract where a contract is broken. The parties who suffer would be entitled to get the contract performed by a third party or by his own agency and to recover expenses and costs, including the compensation from the party who failed to perform his part of the contract. The provision has been provided as an alternative remedy at the option of a party who suffered from the broken contract. Newly substituted subsection 4, substituted section 14 provides a negative list of contracts which cannot be specifically enforced. Clause A of section 14 provides that a party to the contract has obtained substituted performance of the contract in accordance with provisions of section 20. The contract cannot be specifically enforced. Similarly, section 16 of the Principal Act providing for bar to relief for specific contract has been amended for substituting clause A, which provides that specific terms of the contract cannot be enforced in favor of the party who has obtained substituted purpose of the contract under section 20. Some amendment has also been made in so. So in substance, there is now mandatory specific. Now, sir, last judgment on this is Katha Sujata Reddy, 2023 1 SCC 355.
Page number.
Katha Sujata Reddy, 2023 1 SCC 355. Paragraph 51.
Paragraph 51.
51, sir. 51, 52, and 53.
Yes.
In any case, the amendment carried out in 2018 was enacted to further bolster the adherence to the sanctity of contracts. The approach was radical and created new rights and obligations which did not exist prior to such an amendment. Section 10 after the amendment reads as under, which I just read before your honor. The specific performance of a contract shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, 14, and 16. These provisions remain in the realm of court's discretion, was converted into a mandatory provision prescribing a power the court had to exercise when ingredients are fulfilled. This was a significant step in the growth of a commercial law, as the sanctity of the contract was reinforced, with the parties having to comply with contracts and thereby reducing efficient breaches. Under pre-amended Specific Relief Act, one of the major considerations for grant of specific performance was the adequacy of damages under section 14(1)(a). However, this consideration has not been completely done away with in order to provide better compensation to the aggrieved party in the form of specific performance. Sir, initially the court could have considered before 2018. Before 2018, court could have considered whether to grant specific relief or performance or not, and could have considered damages. Sir, again, this discretion, which was that if I have to take to your honor to the Specific Relief Act, since as I could make out your honor is referring to Specific Relief Act.
Yes, yes.
I'll just open Specific Relief Act, sir, also, and I'll demonstrate. So let us see, sir, section 10, which has been referred to here. Sir, section 10, which says specific performance of a contract, specific performance of a contract, because I read before your honor section 10 and it refers to 3 other sections. So section 10 says specific performance of a contract shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, 14, and 16. Now, sir, prior to the amendment, how this section was figuring, if that is to be seen, I'll demonstrate that also. Sir, prior to this amendment, section 10 was reading like this: cases in which specific performance of contract enforceable except as otherwise provided in this chapter, the specific performance of any contract may, in the discretion of the court, be enforced when there exists no standard of ascertaining actual damage by the non-performance of the act agreed to be done, or where the act agreed to be done is such compensation of money for its non-performance would not afford adequate relief. So earlier, sir, it was discretionary in a sense that if the court comes to a conclusion, if court was to come to a conclusion that compensation in terms of money would be an adequate thing in lieu of the specific performance, the court would not like to grant specific performance. Now this section has been amended and it has been provided that it is now mandatory to grant specific performance unless the case falls under the category of subsection 2 of section 11, section 14 and section 16. So subsection 2 of section 11, my case would not fall. Case in which specific performance of contracts connected with the trust enforceable, I am not concerned with that. Section 14 is contracts not specifically enforceable. The following contracts cannot be specifically enforced, namely, where a party to the contract has obtained substituted performance of a contract in accordance with provisions of section 20. Here it is not our case of a substituted performance. Contract, the performance of which involves performance of a continuous duty. My contract is not falling in this category. The contract which is so dependent on the personal qualification of the parties, the court cannot enforce specific performance its material terms. It is also not falling under that. The contract which is in nature determinate. And then, sir, section 16. Personal bars to the relief. There also my case is not. So, as per amended section 10 of the Specific Relief Act, unless the contract falls in the category governed by subsection 2 of section 11, sections 14 and section 16, specific performance of a contract in a suit for specific performance is mandatory if the contract is. So if that is the case, in my respectful submission, the commercial court is fully justified. And in this very judgment in paragraph 15, the court further records that provision which remained in the realm of court discretion was now converted into a mandatory, prescribing a power the courts had to exercise when the ingredients were fulfilled. Therefore, when the prima facie is established and believed by the commercial court that I have a concluded contract at my command, and in that scenario, in my respectful submission, if the interim injunction is not to be granted, then in that case, the mandate of section 10 would not be possible to be achieved. The court would be helpless if they are not restrained today. And at the end of the...
Mr. Dave, I don't want to interrupt my learned friend. I just request, can you let me know with how long more you intend to take?
I'll be finishing within 10 minutes.
Thank you.
I think you got almost everything.
10 minutes. Last submission, not more than 10 or 5 minutes. Last submission. Now, sir, last submission is a written note was submitted by original defendant number 2, respondent number 2, supporting the appeal, raising same contentions, more or less same contentions with the present appellant defendant number 1 as raised. So my submission is defendant number 2, having not opposed the interim injunction application at Exhibit 5 by filing a reply and having chosen to restrict itself to an application under Order 1, Rule 10 for deletion of its name, which has been rejected. it has no right to object to the injunction which has been granted by the trial court. It is not an appeal by defendant number 2. Defendant number 2 could not have preferred an appeal because the issue would have come. Where was your reply opposing the injunction application? None. In that scenario, in my respectful submission, defendant number 2 is not justified in raising grievance against the impugned judgment and order, because the only stand of respondent number 2 before the trial court was defendant number 2. Then I have been wrongly impleaded. I am not concerned with this transaction. And that has been negated by the trial court under order 1 through 10 order, which has not been challenged. Thus, in my respectful submission, summing up, sir, first, this being a hearing in respect of a stay application, stay of a preventive or a prohibitory temporary injunction whereby the parties have been directed to maintain status quo can never be granted. Otherwise, it tantamounts to allowing the appeal from order at this stage by granting the final relief by way of an interim relief, which is not permissible. I cited numerous judgments on that. Point number 2, assuming without admitting and without prejudice my first contention that your honor can have a jurisdiction or your honor can consider entertaining the stay application, then in that case, considering the scope of appeal from order, stay application is also required to be considered in that compass. And if that is to be done, then appreciation of evidence, finding of fact recorded by the commercial court at Vapi cannot be questioned because it is not qualifying as perverse. I cited the judgment showing when it could qualify as a perverse in nature. Then on the issue of territorial jurisdiction, I also made my submissions today. So considering all my submissions and taking view of the present matter from any standpoint, there is no case for granting stay as prayed for by the appellant pending final disposal of the present appeal from order. Present appeal from order can be set down for final hearing at any time convenient to the honorable court. We will definitely cooperate in the expeditious hearing of the same. Timetable can be set down. We cannot have any objection. But there cannot be stay pending final hearing of the appeal from order of the impugned judgment and order. These are my respectful submissions. I am immensely obliged for the patient hearing.
Gaurav bhai છે? Yes, Mr. Cooper.
No. With your lordship's permission,
Yes,
may I rejoin the
Yes,
state?
yes.
Mr. Soparkar is not here present, so he will do his rejoinder subsequently. I'll try and finish off today itself, if your lordship will be kind enough to indulge me for a few minutes.
Yes, no problem.
Mr. Dave,
Yes, now you can continue.
yes. I will be very brief. I will not take up much time because I think that your lordship is now fairly familiar with almost everything
Yes.
which is there on record.
Yes.
My learned friend Mr. Dave has been very, very lengthy in his arguments and very vociferous about his arguments. But with great respect, most of them have been just on basis of various technicalities. And with respect, they are arguments which in the courts are normally known as arguments of desperation. He has done 4 things. First, his arguments completely misrepresent the law. What he argues is not the law. The judgments that he has cited do not bear out what he submits in argument. And I will show that. Secondly, he has deliberately obfuscated various facts. He has not shown to you what the complete facts are, most of which your lordship has already seen, and I won't repeat them. But he has carefully avoided those facts. The third, he has done what is called shadow boxing. He has set up a case for me, which we have never argued. He has invented a case against himself, which we are supposed to have argued, and then he proceeds to knock down that case. So he creates a shadow which he then boxes with. But that is not our case. And the fourth thing which is done and which I submit is extremely serious, is that his clients, I'm sure not Mr. Dave, he must have said it on instructions, has repeatedly specifically false. Let us start with the last one first, the false statements made by them. I heard Mr. Dave say on at least 4 occasions, and perhaps more, that numbers 3 and 4, defendants 3 and 4, or respondents 3 and 4 here, are the shareholders of the appellant or the original first defendant. He says that they are the shareholders because of some that public notice or press note in the public where they mention the name. He then says that, well, a lot of correspondence was also addressed to them. And then he says something very significant. He said that we have never told him who are the shareholders. That according to him, these are the shareholders. And if they are not, then why did we not tell him who are the shareholders? He says, how would I know? Here I am, ready to complete a transaction, but I don't know who the shareholders are. I don't know who I'm going to be dealing with. Now, this is a completely false statement and false to their knowledge. And I'll show you why. First, look at the title to the suit. The Lordship is kind enough to see the title of the suit. Defendant number 1 is MHM Holding. That is the company.
Yes.
Defendant are described. This is his suit. This is how he describes them. Dr. Florian Dawsend, trustee of defendant number 1. And 4, Professor Marcus Stadler, trustee of defendant number 1. Now, I ask myself, since when does the company have trustees and not shareholders? So he has described them as trustees, not shareholders. And trustees of defendant number 1, which is the company. Not a slip of the pen of some not some slip of a pen done by the learned judge in his impugned order. This is his plaint filed by this very, very seasoned business house on the advice of lawyers. But what is more important, please see the shareholders' agreement with the markups done by Jindal.
Mr. Cooper, your internet is very patchy. We're not able to hear you at all.
I'm sorry. I'm very sorry. Yeah.
Maybe we can take a minute to just fix that.
Yeah. Okay. I'm sorry. Am I better now?
Yes, yes. Yes, you are audible.
I'm audible, my lord. I'm very sorry because
yes.
there seems to be some maybe a problem at
ഞങ്ങളും check അറിയില്ല. Yes, you can carry on, Mr. Cooper.
Sir, I think he's continuing to have an internet issue. We're just trying to connect with him at the back end.
Yes, yes.
Sir, in the meantime, since is
I mean,
fine.
yes. Now, if your lordship looks,
Yes.
if my lord is kind enough to look at the shareholders agreement, which was the draft of the shareholders agreement as sent by Jindals. Could I just request someone to screen share it?
Page 321.
Yes, we are having on
Yes.
record, page 321.
Yes, my lord. It's your lordship has on record. Very well. So if your lordship looks at that, you will find on page 321 itself, the top of the page, this agreement is made between, and it gives two names, MHM Betel, guess something long, which I am unable to pronounce,
Yes.
a limited liability company, a German company, having its registered office as so-and-so, hereinafter seller number 1. And 2, MHM somebody else, another company, seller
two.
number 2. These are the sellers 1 and 2. He knows. Not only that, but please look at below that, just above the word recitals. Each of the seller 1 and seller 2, seller and collectively the sellers, and then go to the recitals. In recital A, it says that the company, this MHM Holding, that is the first defendant who's the appellant before your lordship, is a German company, registered in Germany, having so much share capital. And then it says, list of shareholders, copy of which is included in the disclosed documents. He said, I didn't disclose to him. He didn't know about who the shareholders. And then it goes on to say, the shares held by seller 1 according to list, the seller 1 shares held by seller 2 according to the list are seller 2 shares. And it says seller 1 shares and seller 2 shares collectively are the shares, and each of them is a share. So the sellers are seller number 1 and seller number 2. The list of shareholders is disclosed to them. They are told that these are the 2 people who hold all the shares, and these are the shares which are being sold to you. Now, my lord, I ask myself, is it remotely possible for Jindal to say, we don't know who the shareholders are, or that they rely on some press release to discover who are the shareholders? They know very well, but they deliberately don't make them parties. With great respect, I submit, forget all the remaining arguments. On this alone, his injunction must be vacated. He says that, oh, but if numbers 3 and 4 are not the shareholders, then why are they bothered about the injunction? It doesn't hurt them. They can ignore it. The shareholders can go ahead and do what they like. Number 3 and 4 are not the shareholders. That is not correct. The injunction says the injunction is not against 1, 2, 3, and 4. It is against 1, 2, 3, and 4 and their shareholders. So it is against persons who are not parties to the suit. It is against number 1 and its shareholders, whoever they may be, not numbers 3 and 4. I have no problem. They want to pass injunctions against 3 and 4. They pass injunction against the shareholders of number 1, who are those 2 companies mentioned in the SHA, and neither of which is a party here. False statement being made to the court. And conduct of a party is relevant when you are talking about the passing of discretionary orders by a court. When a discretionary interim order is passed, one of the relevant factors to be considered by the court either when you want the injunction or when you don't, when you want to oppose the injunction. In both cases, Supreme Court has said so in Gujarat bottling, that one of the relevant factors is conduct of the parties. Have you come with clean hands? Have you been honest? So first, he has filed a suit against people who are not shareholders, knowing that they are not shareholders. Then he makes a statement to the court which is false, saying that I don't know who the shareholders are, when he knows full well who the shareholders are. When it has been disclosed to him, and he says, I was never told. Every single thing is false. Now the next thing. I'll come to those technical objections of his under Order 43 and under 39 and all that lengthy arguments that have been advanced. I'll deal with them. But the second thing I want to point out is this whole case which has been argued at great length. My learned friend argued yesterday about oral contract being a contract and doesn't have to be in writing. Whoever said that, whoever disagreed with that. Where did anybody argue that you can never have an oral contract? That is not the argument. The argument is not that it is not possible to have an oral contract. Of course it is. In many circumstances, it's possible. Who has argued that? The argument was that if you want to plead an oral contract, there were two separate arguments. Forget about the German law argument. Even under Indian law, if you want to plead an oral contract, all that we argued was, tell us what is the oral contract? What are the terms of the oral contract? What is the date on which that contract came into existence? What is the exact consideration for that contract? All these are the relevant things. So all that we
Yes.
So our argument was that when did it become accepted? It did not become accepted on the day on which it was, or the next day, or the day after. It could not become so accepted. It could not become accepted on that day because, as we have pointed out, as late as 4th November, when we wrote to them saying that we don't want to accept your offer and we are going with somebody else, on 4th November, he writes back saying, okay, is there a gap? If there is a gap between what you are expecting and what I have offered, I am willing to bridge that gap. On 4th November, he's saying that. So till 4th November, then it didn't get accepted. This was the argument, that when did that oral contract spring into existence? Not that you can't have an oral agreement. And for all those judgments we cited, the Supreme Court, this, that, you can have an oral agreement. Of course you can have an oral agreement. Who says no? Then my learned friend argues that I can, once I show I'm entitled to specific performance, the last argument he made. Yes, of course. If you can show that you are entitled to specific performance, you should show that there is a contract, etc. Then the different considerations arise. I'm not saying you can't ask for specific performance. The argument was different. The argument made by us was, A, that there is no agreement, because you have not been able to say when that agreement came, because the agreement before 4th November could never have been entered into, for the simple reason in 4th November, you're still talking about the gap in consideration. It's like saying that I have offered you 100 rupees, you are expecting 150 rupees, there's this gap, let's bridge the gap. Can there be a concluded contract? when I say that let's bridge the gap? Then my learned friend made a very peculiar argument. He said, when I make a non-binding offer, it means that it is not binding till it is accepted. Well, it's an argument I've never yet heard in any court of law before. And it certainly is not what the Contract Act says. An offer is always binding once it is accepted. And it is always not binding till it is accepted. If I say that I want to buy your pen for 100 rupees, I can always withdraw it anytime before you accept it. If you don't accept it, I can say, oh, I've changed my mind. I no longer want to buy your pen. But if you say, yes, here is my pen, give me the 100 rupees, it becomes a binding contract. So what do you mean by saying a non-binding offer? A non-binding offer means don't hold me to it. I am offering 100 rupees. Let's talk about it. Let's discuss terms. If we come to a complete deal, well, okay, then I'll talk about paying you 100 rupees. Right now, please don't think I'm not tied down to giving you 100 rupees. That is the meaning of non-binding offer. No, otherwise, just imagine what he's saying. He gives a non-binding offer, I'll give a non-binding acceptance, and we'll have these non-binding contracts. The Contract Act for creating a contract, the Contract Act contemplates binding offers and binding acceptance, creating a binding contract. There's no such thing as a non-binding offer under a contract. So his argument that, well, when I say non-binding, I only mean that it is not binding till it is accepted. Of course, it is not binding until it's accepted. No offer is ever binding until it's accepted. So once again, these are all just bogies which are created. Now, let's have a look at the law, which my learned friend has taken great pains to cite, that you cannot upset an interim stay under Order 43. You cannot upset it in appeal because it is a discretionary order. Of course, it's a discretionary order. But every discretion exercised by any court, by any judge at any time must be discretion which is exercised judiciously, which is exercised reasonably, which is exercised in a manner consistent with law. A lower court cannot do something which is patently illegal. And then the appeal court gets told, sorry, it may be illegal. You have a different view of the law. You can't interfere. Stay out of it. That is not the law. There are every day in our courts, interim orders are upset by appeal courts. It's not an unusual thing. It happens literally every day in our courts, in every high court. It happens from high court to high court, happens from high court to Supreme Court, happens from lower courts to higher courts. It happens across the board. There is no such bar as is sought to be argued by my learned friend. And if I may just show your lordship 3 judgments. First, my lord, I just show your lordship 3 judgments of the Supreme Court, culminating with my learned friend's judgment, which he cited, of Justice Pardiwala of the Supreme Court. The first judgment, if your lordship is kind enough to see, I don't know, is there somebody who can give this to my lord, or is there a... This the judgment of 2019 SCC online. No, not that. I'm sorry, not that. I'm sorry, my lord.
Some citation kayu ke chhe nahi sabe.
I'm sorry. I'll just give you the citation. I'm so sorry. This one, Lakshmikant Patel. Judgment of Lakshmikant Patel versus Chetan Bhai Shah and others. It's 2002, 3 Supreme Court cases, page 65.
2003. Yes.
Okay. Now, my Lord is kind enough to go directly to the judgment internal page 74, paragraph 17.
Yeah.
Where it talks about interference with the discretion of the trial court. Para 17. We are conscious of the law that this court would not ordinarily interfere with the exercise of discretion in the matter of grant of temporary injunction by High Court and the trial court and substitute its own discretion therefore, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the order of the courts under scrutiny ignores settled principles of law regulating grant or refusal of interlocutory injunction. An appeal against exercise of discretion is said to be an appeal on principle. The appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below, solely on the ground that if it had considered the matter at the trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken a different view may not justify interference with the trial court's exercise of discretion. See Wander. My learned friend also cited Wander's case. It's very well known. I don't want to reproduce it. However, the present one is a case falling within the well-accepted exceptions. Neither the trial court nor the High Court have kept in view and applied their mind to relevant settled principles of law governing grant or refusal of interlocutory injunction in trademark and name disputes. A refusal to grant an injunction in spite of availability, which are prima facie established by overwhelming evidence and material available, justifying the grant, occasion a failure of justice and such injury to the plaintiff as would not be capable of being undone at a later stage. The discretion exercise is neither reasonable nor judicious. This is not the principle of law. A second judgment, if your lordship is kind enough to see, is the judgment of Seema Arshad Zahir and others versus Municipal Corporation of Greater Mumbai and others. This is 2006, 5 Supreme Court cases, 282. Somebody, you can hand it over to your lordship.
હું પછી formally બી આપી દઈશ, અત્યારે વાંચવા.
My lord is kind enough to see paragraph 32.
Page 95 જોશો.
Page 295. Internal page 295 of the judgment. Paragraph 32. My lord has got that? Paragraph 32. It's on internal page 235. 295, I'm sorry, 295.
સર ઉપર 108. કોલમમાં 108.
Paragraph 32, 32.
Yes.
Where the lower court acts arbitrarily, capriciously, or perversely in the exercise of its discretion, the appellate court will interfere. Exercise of discretion by granting injunction where there is no material or refusing to grant injunction by ignoring relevant documents produced are instances of action which are termed as arbitrary, capricious, or perverse. When we refer to acting on no material, similar to no evidence, we refer not only to cases where there's total dearth of material, but also to cases where there is no relevant material or where the material taken as a whole is not reasonably capable of supporting the exercise of discretion. In this case, there was no material to make out prima facie case. Therefore, High Court in its appellate jurisdiction was justified in interfering in the matter and vacating the temporary injunction granted by the trial court. This is the principle. Now, there is no difference between this and the principle of law which has been enunciated by the Supreme Court in the judgment which has been cited by my learned friend. Your Lordship, that Ramakant Choksi's case, now, so Your Lordship will see paragraphs 33 onwards of that judgment. My learned friend read parts of it, so I won't reread all of it. I just want to emphasize a few sentences. Paragraph 33, above it, principles governing grant of temporary injunction. So first, the court in paragraphs 33 and 34 lay down what are the principles which govern grant of an injunction. So first, prima facie case, the burden is on the plaintiff to prove that there is a prima facie case. Then once you satisfy that is not enough, you have to also satisfy about the other parts, about the irreparable injury, no other remedy, etc., etc., etc. Then we will come to paragraph 35, meaning of the expression perverse. Any order made in conscious violation of pleading and law is a perverse order. So if the impugned order violates the pleadings and the law, it's a perverse order. So if the order does something which the law says you shall not do, it's a perverse order. First sentence. Then in so-and-so, the court observe a perverse verdict may probably be defined as one that is not only against the weight of evidence, altogether against the evidence. Perverse as turned the wrong way, not right, distorted from the right, turned away or deviating from what is right, proper, correct, etc. Then they've given various definitions. And in the definitions, Your Lordship may only look at definitions A, B, and C. A, B, C, and E, not D. D is a moral perversion. It talks about something being wicked or wayward. I'm not on that. I'm obviously not suggesting that the court was wayward or wicked. So we talk perverse showing deliberate determination to behave in a way that most people think is wrong, unacceptable, or unreasonable. Perverse deliberately departing from what is normal and reasonable. Then C, perverse in a case of a law is when it is against the weight of evidence or the direction of the judge on a point of law. And E, when a perverse verdict may probably be defined as one that is not only against the weight of evidence, but is altogether against the evidence. 37. The wrong finding should stem out of a complete misreading of the evidence. So Your Lordship will have to see, has the trial court misread the evidence? Has it looked and found something in the evidence which it should not have found? If it has imagined something, it has surmised something, then it is perverse. So, safest approach on perversity is the classic approach on the reasonable man's inference on the facts. If the conclusion on the facts in evidence is possible, there is no perversity. If not, the finding is perverse. Pause here. I am not suggesting that if Your Lordship were to take a slightly different view on the court, sometimes on the same thing, two judges may differ. One judge comes to one conclusion, the other one comes to another conclusion. Both are possible conclusions, but Your Lordship prefers conclusion B to conclusion A. The trial court preferred conclusion A to conclusion B. Then Your Lordship will say, look, it's an interim order. It's a possible view. There's nothing perverse about it. I will let it be, even though I don't agree with it. But if the view taken by the trial court is such that it is not a reasonable view, then you will interfere. This is exactly what the three Supreme Court judgments, including the judgment of Justice Pardiwala, say. Is it something reasonable? Now let's look at what are the reasonable things that the impugned judgment does, or the unreasonable things. One, it passes an order against people who are not parties before it. Forget anything else. Forget number 3, 4, whatever. It passes an order against MMH, that is the first defendant and the appellant before you, and its shareholders, whoever they may be. That is an order beyond the pleading. That is an order against people who are not present. I ask myself one question. Is that something which a reasonable person, and when one talks of reasonable person in such a context, one obviously means a reasonable judge. Is this something which a reasonable judge would do? A reasonable person? Would it stand to reason to say, pass an order against somebody who is not before you? Is that reasonable? If the answer is yes, then the order is reasonable. But if the answer is no, then the order must be set aside. And with my greatest of respect, I submit that it is impossible to say that it is a reasonable thing to pass orders against people who are not before the court. So I don't hear you, you're not before the court, and I'll pass an order against you. That, with respect, is not reasonable. Secondly, there is under the agreement, under the process note which was issued, the letter which started the whole process which was issued, there is a specific provision that German law is to apply. Not only is it in the process note, this continues throughout, even in the even in the draft shareholders agreement, where markups were done on both sides, even the markup done by Jindals, by the plaintiff, shows that German law shall apply. I'll show it to your lordship if there's any. It specifically mentions it. So if German law is to apply that provision, then surely a reasonable person would say, what is German law? That would be reasonable. Or it would be at least reasonable for someone to say that though German law is to apply, I will not apply German law, but I will apply Indian law for XYZ reason, whatever may be the reason. Then, of course, your lordship will see whether that reason is reasonable or not reasonable, but there must be some excuse given. Now, I've gone through the whole plaint, line by line, and I do not find a single line which mentions German law. Not one line. Ek shabd nahi. Nothing in the entire plaint does Jindal talk about German law. Not only that, nowhere in the impugned judgment is there any mention that German law should apply, but I am not going to apply it because of XYZ reason. The plaintiff and the impugned judgment both pretend that this doesn't exist. And it's not as if they don't know it exists. Jindal knows it exists and has suppressed it. Again, going back to conduct. But more importantly, the MMH argued before them that German law is to apply. That is one of the replies. That's one of the things placed before them, that you have German law is to apply. He has to deal with that argument. Now, my lord, again, I ask myself, when something says German law shall apply, and the plaintiff deliberately ignores it, when it is pointed out to the judge that German law is to apply, and he's not applying it, and the judge ignores it completely, is that reasonable behavior? Is that the reasonable conduct? Is that judicious conduct? Or is it capricious and arbitrary and perverse? And with my very respectful submission, it is absolutely perverse, with no possible excuse for not applying it. Unless, as I said, a court can say, yes, you are provided for German law, But there is some provision in Indian law which says you cannot exclude German law. You cannot exclude Indian law, and Indian law will apply even if you say it is German law, which of course is not true. There are several judgments, and I have, my lord, in fact, given your lordship a list of judgments on that in my submissions. So German law has to apply, but he's ignored it. Is that reasonable? And if it is unreasonable, that's the next unreasonableness and the next perversity which calls out for this impugned order and impugned injunction to be struck down. Then, my lord, come next thing. He says that a contract was formed. According to the plaintiff, he says, I made my second offer, non-binding offer, and it got accepted by correspondence. So, therefore, he says, that is the contract. Again, the document is before him. What is the document? The document categorically saying on 4th of November, and I have already shown it to your lordship. I don't want to repeat myself. On 4th of November, your lordship remembers that there was an email. There was an email sent by us to them saying, I don't accept your offer. On 4th of November, they immediately write back and say that, sorry, is there a gap? What is the gap? We will try and bridge the gap. They don't say, what are you talking about? There's a concluded contract. Now, with this exchange of mails in front of him, which are vital, which completely summarize the whole thing. On 4th November, there was no deal. He doesn't deal with it. He doesn't mention it. He doesn't say why. Therefore, how could that deal have been? How could there have been a deal before 4th November if on 4th November they are saying that we will still bridge the gap? And gap in what? Gap in consideration. Consideration is the single most important element of any contract. Now, in this very important element, there is a gap. Now, if there's a gap, there's no conclusion. Now, if there is no conclusion, I again ask myself, is it reasonable for the judge to have ignored it? Is it reasonable to come to a conclusion there was a concluded contract? And if not, is that not also perversity? One more example of perversity.
Mr. Kumar, there was no mention of acceptance from your side, no?
There is no letter or email that says.
You have conveyed that you have accepted your offer or something like that. Never mention of that.
Never mentioned. There is not a single mail which says, I accept your offer or your offer is accepted. The only time we've written to them was when they made their first offer. We said, yes, as far as your first offer is concerned, we agree to move you to stage 2. Yes. So, it's like this. Let me explain. It's very simple. If I am advertising for a job and 30 people apply for that job, out of the 30, I say, look, I check everybody, I interview and I say, okay, you 10 people are acceptable. The remaining 20, please go home. And I move 10 people to the next round for the next round of interview. Does it mean that I've accepted all 10 of them? Of course not. It only means that I find you acceptable enough to move you to the next stage. And I've told them in the beginning that this is going to be 2 stages. So you will be moved to the next stage only if I find that you're acceptable through for stage 1. Now, I have moved several people into stage 2. Can all of them say that you have accepted my offer? Every one of them? And that you're dealing with me now? Obviously not. And when he says that, please, I'm making you my first final offer, but I'm making it on the condition that you don't negotiate with anyone else. I said, sorry, your lordship has seen that. And my learned friend rightly conceded that I told him, no, I am not going to negotiate only with you. I'm negotiating with everybody else also. So he knows that I'm negotiating with several people. If I'm negotiating with several people, how can it be that I accept his contract? It beggars common sense, not? Therefore, when I'm negotiating with other parties, it cannot be that Jindal's offer is the only one which is under consideration. There are several offers under consideration. Now, he made, as your lordship saw, he started with 360 million. Then he went up to 378 million. Then he went down to 369 million. And he says, therefore, my 369 got accepted. So just look at the absurdity. The 378 million offer, without any break fee, without mention of a break fee, is not accepted by me. But according to him, the 369 offer, which is lower, with a 9 million break fee tossed in, is suddenly the one where I accept. It beggars common sense. That I accept an offer which is 9 million less with a 9 million break fee in it. And that I have suddenly accepted, according to him. It's an absurdity. Nothing was accepted. We are talking. We are negotiating. He, as I pointed out, he sent a draft with a write-up. When I send back a draft with a different write-up, it shows I have not accepted his offer. But what is worse is that he doesn't even accept what I've done. I can understand. He says, okay, your write-up, I've accepted. Now it's all done. He then makes another write-up, which he never sends to me, which he himself writes that I have made another write-up. Would you like it to show to anyone? No, I don't ask for it. He tells me, please, would you want one more? I said, no, I don't ask for it at all. He never sends it to me. So I don't even know what are the now new changes he wants. We don't even know that. But there is a contract according to the learned judge. Once again, my lord, with great respect, this is perversion. Then, my lord, next point on which there is again perversity. Territorial jurisdiction.
What
We
he said
point out-
that territorial jurisdiction is decided in the.
I'll deal with that. I'll deal with this res judicata. I'll deal with the res judicata point. I'm coming to that.
Yeah.
First, I want to deal with the perversity. Then I'll deal with his res judicata. On territorial jurisdiction, what he says is, and he has cited those judgments to say that where the property is situated, there it has jurisdiction. And he says number 2 has some property in Vapi, so Vapi court has jurisdiction. And he says, yes, because I am going to take over defendant number 2 also. With respect, he has given no answer to what we had argued in the first time. That there are several subsidiaries of MMH all over the world. Some of them are even mentioned in the agreement. Those subsidiaries have properties in different parts of the world. Is it suggested that every such court will have jurisdiction all over the world? Secondly, what is being sold is not property. So a judgment which says that territorial jurisdiction is where the property is situated has no application, because property is not being sold. The property belonging to number 2 continues and will continue to belong to number 2. Is there any change in the ownership of the property belonging to Huber Group number 2? The answer is no. There is no change in the ownership of the property. The property will not belong to some other party. It will not belong even to Jindal's or to Marugappa Group. It will continue to belong to Huber Group number 2. Similarly, number 2, the shares of number 2 are held by MMH. The shares of MMH are being sold. Whoever gets control of MMH naturally gets control of all the subsidiaries, but he is not buying the subsidiaries. He is buying the company, the parent company. And I gave the example of, my lord, of a company. For example, Reliance. Reliance has several subsidiaries. If all the shares of Reliance, all the shareholders get together and say we are selling the shares of Reliance, what is being sold are the shares of Reliance, not the shares of a company which is a subsidiary of Reliance. Only therefore, if the shares of Reliance are being sold, only the court where Reliance has its headquarters will have jurisdiction. No other court. Because it's only the shares which are being sold. The fact that there are properties belonging to some subsidiary which may be in some other court doesn't give that court jurisdiction. Reliance may have a subsidiary which happens to have some property in Bombay, some subsidiary which has a property in Calcutta, some property in Gujarat, somewhere all over the world. If you have properties abroad, none of those courts get jurisdiction because none of those properties is being transferred. Territorial jurisdiction for property comes when the property is being transferred. Property is not being bought or being sold. Property remains that of number two. What is being bought and sold are shares, movables, shares. The shares are being sold of a German company. Any challenge to the sale of shares has to be where the company is situated, which is Germany. That is why we say you have no territorial jurisdiction. Now, that's on the face of it. So how does it come about with jurisdiction? First, you say that they had negotiations and they met somebody in Vapi. So if you go to Vapi and have a look at the property and you meet somebody in Vapi and have a cup of tea or have dinner or lunch or whatever, you get jurisdiction. Or because the property of the second event happens to have one property in Vapi, Vapi gets jurisdiction. Is this reasonable? Is this a judicious approach? Is this in consonance with well-established law? I mean, the law of jurisdiction is too well-established, not? This is capricious. This is arbitrary. This is, on the face of it, illegal. And therefore, it is unreasonable. No reasonable man could ever say that therefore this has jurisdiction. This is unreasonable. It is therefore perverse. One more example of perversity. So on every single finding that the learned judge has done, he has been perverse. The impugned judgment is perverse from beginning to end, and therefore it must be struck down. Now let's come to that fourth, this point that your lordship just brought up on the question of res judicata. Well, the greatest of respect to my learned friend, that is what they call a point in geometry. It has position but no substance. Of course, we are all very familiar with the principles of res judicata. But what is res judicata? If I file something and a court passes an order on a specific issue, after the court has passed that order, I take out another application for some other relief, asking for on the same issue. Then res judicata principles may come in. When they come in or not, there is some discussion in various judgments. I don't want to get into that really. It's not relevant. But res judicata comes in only first there is an order. Subsequent to that order, you seek a subsequent order, and then the principle of res judicata come in. Now, what happened here? He filed the application for interim injunction first. That's the first proceeding. Subsequently, I filed the 711 application. The learned judge passed the orders on the same day, that is 20th of January 2025. On the same day, he passed the orders. How can there be res judicata? How can there be res judicata that one order, if at all, the first order must be of the application which was made first? Logically, it would therefore be the interim application. So if at all that was the application which was filed first, but really it can't apply when the order is on the same day. Because it's not as if after that order I took out an application or I did something after that application. He decided on the same day he passed he handed over two orders. Where is the res judicata? How do I say that this order, after this order, you filed another application and then you tried to seek the same relief? I did not seek the same relief afterwards. That is because all those judgments are completely irrelevant. This whole thing is a bogey he has created. The res judicata. Just it's meaningless here. There is no res judicata. Just give me just 1 minute.
Yes. સુપારકરભાઈ તમે adjust કરી દો છો conclude કે
ના સાહેબ આજે નહીં કરું, કાલે હું 2:30 થઈ ગયું,
Yeah.
2:30
No,
પતાવી દઈશ.
I'm more or less finished. I'm just one thing.
yes yes
Yeah.
આમ તો કુપર સાહેબે બધું કરી દીધું છે સાહેબ.
સાહેબ,
Yes.
હું
I'm virtually
કુપર સાહેબના ને કુપર સાહેબની દલીલો મેં સાંભળી, એમાંથી એક પણ હું રિપીટ નહીં કરું.
બરાબર right.
I don't intend to repeat. I will take up issues which I believe are required to be explained in little more greater detail. બાકી એકે વસ્તુ હું રિપીટ નથી કરવાનું. I was out here when Mr. Cooper started.
yes yes કુપર sir તમે continue કરો વાંધો નહીં. You may continue Mr. Cooper. અનમ્યુટ કરવાનું છે કુપર સાહેબ.
Sorry, I'm sorry, my lord. My lord, does your lordship is keeping this matter tomorrow morning or in the afternoon?
No, he's saying at 2:45. Mr. Suparkar wants at 2:45.
Very well. My lord, may I only request that
Yes.
if your lordship can just keep it for half an hour at 12:30, I'll finish it half an hour, then Mr. Suparkar
Yes,
can
yes,
review.
no problem.
That's
Tomorrow
okay.
12:30, no problem.
Tomorrow
અને
12:30.
સાહેબ હું પણ જો 1 વાગે ફ્રી થઈ ગયો હોઈશ તો આવી જઈશ, મને વાંધો
તમે બી આવી જાઓ, તમે વહેલું.
અત્યારે ડાઉટફુલ લાગે છે, હું 2:30 ચોક્કસ આવી જઈશ.
Yeah. So I'll finish in.
I try
Yes.
to be there. Once my friend Mr. Cooper finishes, if I am available, I'll be there. Otherwise,
Yes.
in the afternoon.
Very.
Mr.
That-
Cooper,
that-
you are also having your return arguments.
Yes. No, I'm obliged, my lord. So tomorrow at 12:30, I'll finish it in half an hour, and then Mr. Soparkar, if he's available, will continue. If not, we take it up at 2:30.
Dhavalbhai, you will be there no, at 12:30 tomorrow.
12:30, sir, if I am held up, someone from my office will be there.
Very
Studying and working.
No problem,
Fair-
no
fair
problem.
enough.
My presence may be SPs, they are not available.
Very.
I'll try to be here.
I'm obliged, my
Okay,
lord. I'm obliged.
okay. So tomorrow 12:30.
12:30, my lord.
Thank you, sir.
May we leave, sir, now?
Yes, we will leave.
Thank you, sir.
I'm obliged, my lord.
Yes.
Thank you, sir.
સાઈન કરવા બોલી આવશે એનું હોય ને બીજાનું